Good evening, everyone. Tonight, we're highlighting key developments in immigration policy from May 29 to May 31, 2025. No editorial bias, just straightforward reporting with a side of skepticism. Let's get to it. On May 29, the Supreme Court ruled that the federal government has the authority to end temporary protected status, TPS, for nationals of Cuba, Haiti, Nicaragua, and Venezuela. Over 530,000 individuals who have been living and working in the U.S. under TPS protections will see that designation rescinded. Proponents of the decision argue it restores executive control over immigration policy, citing the temporary nature of TPS. Opponents point out that many beneficiaries have established lives here, working, paying taxes, and raising families, and now face uncertainty about their future status. The ruling was issued without an accompanying opinion, leaving implementation details to the administration. The next day, May 30, the Department of Homeland Security released a list of more than 500 sanctuary jurisdictions, states, counties, and cities that limit cooperation with federal immigration enforcement. DHS warned that these jurisdictions could face legal action or risk losing certain federal grants if they maintain policies that restrict local law enforcement from complying with Immigration and Customs Enforcement (ICE) detainer requests. Supporters of sanctuary policies maintain that local autonomy helps build community trust and prioritizes public safety by encouraging cooperation between immigrant communities and law enforcement. Federal officials counter that such policies undermine national immigration laws and hamper efforts to remove individuals convicted of serious crimes. Also on May 30, the Supreme Court decided to allow the administration to end the humanitarian parole program known as CHNV for Cuba, Haiti, Nicaragua, and Venezuela, which, since 2022, permitted migrants with US-based sponsors to live and work in the country temporarily. This decision effectively removes legal protections for more than 500,000 people admitted under that program. Supporters of ending CHNV characterize it as a necessary correction to curb irregular migration and ensure consistent enforcement of border security. Critics contend that the program was established with stringent vetting procedures, and terminating it abruptly will leave families in limbo, many of whom fled unstable conditions or natural disasters. On May 31, two related stories surfaced. First, the Department of Justice began prosecuting unauthorized immigrants under the Alien Registration Act of 1940, a statute requiring non-citizens without valid legal status to register with immigration authorities. Since April 11, dozens of migrants have been charged for failing to comply, facing up to 6 months in jail and potential fines. Supporters argue enforcing this long-dormant law promotes accountability and deters visa overstays. Detractors say it diverts resources from more serious criminal cases and can result in family separations over paperwork lapses. Second, it emerged that U.S. Customs and Border Protection (CBP) has been collecting DNA samples from migrants, including minors, as part of family reunification procedures and placing those profiles into the FBI's Combined DNA Index System, CODIS, even when migrants have not been charged with crimes. Officials from CBP state that DNA collection is intended to verify familial relationships and prevent human trafficking. Privacy advocates argue that storing biometric data in a criminal database raises serious civil liberties concerns and may inadvertently label asylum seekers as potential suspects. Over these 3 days, from May 29 through May 31, we saw 1. TPS revoked. The Supreme Court allowed the removal of protections for over 500,000 migrants. 2. Sanctuary jurisdictions targeted. DHS published a list of 500+ localities at risk of federal funding cuts. 3. Humanitarian parole ended. The court cleared the way to terminate CHNV parole protections for migrants with U.S. sponsors. 4. Registry enforcement. DOJ revived a 1940 law to charge migrants for failing to register. 5. DNA collection. CBP's use of DNA in CODIS stirred privacy debates. In short, policy changes over these 48 hours have revolved around rescinding temporary protections, scrutinizing local cooperation, reactivating old statutes, and expanding biometric data collection. Each action has its advocates and critics, and the impacts will unfold over months and years, affecting individuals, communities, and the broader immigration system. That's it for our concise tour of late May 2025 immigration news. In the theater of policy, the spotlight moves fast, so keep your tickets close and your facts closer. Good night.